Start. There are judicial precedents available on the interpretation of the aforesaid provision, albeit the Delhi High Court, in court on its own motion versus Central Bureau of Investigation. The Delhi High Court dealt with an argument similar to the contention of the respondent that Section 170 Code of Criminal Procedure prevents the trial court from taking a charge sheet on record unless the accused is taken into custody. The relevant extracts are as under. Word custody appearing in this section does not contemplate either police or judicial custody. It merely connotes the presentation of accused by the investigating officer before the court at the time of filing of the charge sheet, whereafter the role of the court starts. Had it not been so, the investigating officer would not have been vested with powers to release a person on bail in a bailable offence. After finding that there was sufficient evidence to put the accused on trial, and it would have been obligatory upon him to produce such an accused in custody before the magistrate for being released on bail by the court. In case the police/investigating officer thinks it unnecessary to present the accused in custody for the reason that accused would neither abscond nor would disobey the summons, as he has been cooperating in investigation and investigation can be completed without arresting him, the IO is not obliged to produce such an accused in custody. It appears that the learned special judge was laboring under a misconception that in every non-bailable and cognizable offence, the police is required to invariably arrest a person even if it is not essential for the purpose of investigation. Rather, the law is otherwise. In normal and ordinary course, the police should always avoid arresting a person and sending him to jail if it is possible for the police to complete the investigation without his arrest, and if every kind of cooperation is provided by the accused to the investigating officer in completing the investigation. It is only in cases of utmost necessity where the investigation cannot be completed without arresting the person. For instance, a person may be required for recovery of incriminating articles or weapon of offence, or for eliciting some information or clue as to his accomplices, or any circumstantial evidence that his arrest may be necessary. Such an arrest may also be necessary if the concerned investigating officer or officer in charge of the police station thinks that presence of accused will be difficult to procure because of grave and serious nature of crime, as the possibility of his absconding or disobeying the process or fleeing from justice cannot be ruled out. In a subsequent judgment, the division bench of the Delhi High Court, in court on its own motion versus state, relied on these observations in re-court on its own motion (supra) and observed that it is not essential in every case involving a cognizable and non-bailable offence that an accused be taken into custody when the charge sheet/final report is filed. The Delhi High Court is not alone in having adopted this view, and other high courts apparently have also followed suit on the proposition that criminal courts cannot refuse to accept a charge sheet simply because the accused has not been arrested and produced before the court. In Deenadayal Kishanchand and others versus State of Gujarat, the High Court observed as under. It was the case of the prosecution that two accused, that is, present petitioners numbers 4 and 5, who are ladies, were not available to be produced before the court along with the charge sheet, even though earlier they were released on bail. Therefore, as the court refused to accept the charge sheet unless all the accused are produced, the charge sheet could not be submitted, and ultimately also by a specific letter. It seems from the record the charge sheet was submitted without accused numbers 4 and 5. This is very clear from the evidence on record. I must say at this stage that the refusal by criminal courts, either through the learned magistrate or through their office staff, to accept the charge sheet without production of the accused persons is not justified by any provision of law. Therefore, it should be impressed upon all the courts that they should accept the charge sheet whenever it is produced by the police with any endorsement to be made on the charge sheet by the staff or the magistrate pertaining to any omission or requirement in the charge sheet. But when the police submit the charge sheet, it is the duty of the court to accept it, especially in view of the provisions of section 468 of the code, which creates a limitation of taking cognizance of offence. Likewise, police authorities also should impress on all police officers that if charge sheet is not accepted for any such reason, then attention of the sessions judge should be drawn to these facts and get suitable orders so that such difficulties would not arise henceforth. We are in agreement with the aforesaid view of the High Courts.